While I was in New York over the weekend, news broke that the Supreme Court took a huge Second Amendment case, and I'm predicting a big win here. Now, while the case is a Hawaiian case, California, New York, New Jersey, and Maryland are now shaking in their boots. And I'm going to tell you something that you might not hear in most places is something to watch out for. Something similar that they did in New York. Hey everybody, welcome back to Guns and Gadgets. I am Jared, and today we are breaking down a major Supreme Court development that could reshape how gun rights work across the country, specifically concealed carry rights. Now, the case in question is Wolford v. Lopez, and it centers on this so-called vampire rule, a restrictive scheme that inverts the typical assumption of where a licensed carrier may carry. Now, if you care about the Second Amendment, law, carry rights, and how courts interpret our constitutional protections, stick with me. I'll walk you through the legal background, what's at stake, where the courts are split, and what outcome we should see here in the Supreme Court. Now, let's dive in. Real quick, I know a lot of you out there like to repair and modify your own guns, and if you're looking for a way to take your hobby to the next level, the Sonoran Desert Institute can help. The online programs at SDI cover armorers courses, gunsmithing, ballistics, woodworking and finishes, shooting sports management, and more. Plus, tools and materials are shipped directly to your door for hands-on practice. It's never been a better time to get an education that you can actually use on the job. So what are you waiting for? Visit sdi.edu/GNG, links are down below, or call 480-999-4767 to learn more. All right, I think we should start out at what is the vampire rule anyway? While this only affects 5 states, the other 45 probably don't know the term. The term is tongue-in-cheek from gun rights advocates, but it captures an important twist. Rather than permitting carry on certain properties, the vampire rule makes carry illegal by default unless a property owner gives affirmative consent. Remember the old movies, the old horror movies, where a vampire couldn't cross the threshold unless you invited them in? Same here. A concealed carrier couldn't cross the threshold into someone's privately owned business or residence unless they were specifically given consent from the owner. In practice, it means that for many public accessible private places like stores, restaurants, malls, even if you have a concealed carry permit, you cannot carry there unless the business explicitly allows it. That flips the usual presumption on its head. It used to be that you could carry wherever unless a privately owned property posted guns aren't allowed. And then everybody who was a conservative or a gun owner knew not to give them any money because they hated our rights. Well, this flips that on its head. Now, Hawaii has such a law, and similar schemes have been adopted in places, like I mentioned, New York, New Jersey, California, and Maryland. Now, gun rights advocates argue that this effectively bans licensed carriers in the vast swaths of public life, undermining the general right to carry recognized by the Supreme Court in Bruen not too long ago in 2022. So Wolford versus Lopez asks, is this sort of prohibition constitutional, or does it run afoul of the Second Amendment? Like I said, I am predicting a thrashing by the Supreme Court here. Now, to understand how the court will analyze this, we need to recap 2 key Supreme Court precedents. New York State Rifle and Pistol Association versus Bruen back in 2022, and more recently, U.S. versus Rahimi in 2024. In Bruen, the court held that when government imposes restrictions on the right to publicly carry, it must show that the restriction is consistent with this nation's historical tradition of firearm regulation. In other words, is there a historical analog to the challenged regulation? If not, the law fails, period, point blank. However, Bruen also acknowledged that certain sensitive places like schools, polling places, and government buildings could justifiably be off limits. And that's one of those open doors that the anti-gunners look to just utilize to their advantage. But Bruen warned courts not to expand sensitive places too loosely. For instance, you can't just declare every public assembly site a sensitive place. Now, Rahimi modifies the historical analog inquiry somewhat. The court in Rahimi made clear that courts should not treat the historical test as a rigid, amber-trapped exercise where only identical 18th century laws count. There must be room for analogous reasoning and general principles from the historical tradition. In short, The modern test is whether a regulation is consistent with the historical tradition in a principled way, but not necessarily a carbon copy of an old law. And that gives some breathing room, but it's not unlimited. So this is a crucial issue here. It's a crucial fact because Wolford versus Lopez in the Ninth Circuit, in upholding Hawaii's vampire rule, leaned heavily on the Rahimi decision, arguing that even if you can't find a perfect analog, you can rely on general regulatory principles from history. Now the question now is, will the Supreme Court accept that line of reasoning or push back against the expansive reading? Now, part of what makes Wolford versus Lopez compelling is that the courts are divided on this issue, and that is when the Supreme Court gets involved, which is one of the reasons the Supreme Court has granted a certiorari for this case. They are taking this case up. We will hear this case. The Ninth Circuit became the very first to uphold a vampire-style law, which was Hawaii's version. And that was a big moment because it bucked the trend of other courts in joining or striking down similar rules. Conversely, in the Second Circuit, the court struck down a New York ban, a default ban is a better way to put it, on publicly accessible private property, i.e. a similar opt-in property owner regime. That was the Concealed Carry Improvement Act that Hochul put into immediately after the Supreme Court ruled in Bruen. Now, even after being asked to reconsider in light of Rahimi, the Second Circuit reaffirmed its view that such laws likely violate the Second Amendment. The Third Circuit also intervened recently, blocking New Jersey's version of a vampire rule, saying that while restrictions on carry in certain contexts may resemble historical regulations, the scope, which is how and why, of the modern provision, well, it was too broad to be rooted in the tradition. So you have a true circuit split here, the Ninth carving out a path to uphold it while others are rejecting it. And that divide invites the Supreme Court intervention. Now, at stake is more than just one statute in Hawaii. This is about how far states and localities can go in restricting carry in places where people regularly go. If the Supreme Court upholds the vampire rule, that could validate similar schemes in other blue and purple states. And if you don't think other states will accept this type of reasoning if the Supreme Court upholds it, you are just living under a rock. And if the Supreme Court strikes it down, it reaffirms the broad protective posture of public carry. Now, here are some possible outcomes and what they mean. The first is Supreme Court strikes the vampire rule down, which would be favorable to concealed carry rights. The court could hold that, making carry illegal by default without property owner permission is too far outside the historical tradition and inconsistent with Bruen's principles. And that would be big. It would be a huge win for gun right advocates. The second is the Supreme Court could uphold with limitations or narrow carve-outs. That would mean the court might allow some variation. For example, require some defined categories of property to permit carry, or limit the rule to very narrow contexts. It could uphold Hawaii's law in a more confined way rather than opening the door to sweeping application. A third option is SCOTUS upholds broadly, which is bad for carry. That would mean the court would buy the Ninth Circuit's reasoning that modern laws can diverge if they're grounded in general principles, even without close historical analogs. Now, that risks giving states more leeway to push restrictive carry regimes. And number 4 is SCOTUS would remand the case and clarify the doctrine. Now, the court could say, we're not deciding the merits yet, but we're refining how courts should apply Bruen and Rahimi, and we're going to send it back for reconsideration under new guidance. And there's also the possibility of sensitive places, and where lower courts could interpret that decision as a license to expand what qualifies as sensitive, which would further constrain carry. Now, beyond that, the decision will signal where the court stands on how flexible the historical analog doctrine should be. Will it allow lower courts broad interpretive leeway or force stricter adherence? Now, that feeds into every gun rights case going forward. Not just this vampire rule, but all of them. All laws about open carry, concealed carry, or restrictions in various zones. They will all be affected by what the Supreme Court will decide here. As we wait for the decision, here are some things that I see as key questions and signals that we need to watch for. And when this does get scheduled for oral argument, I will cover it live, so subscribe to the channel if you want to know more. But a majority decision on historical analogs is, will the Supreme Court accept the ninth's reading of Rahimi, that you can uphold modern laws without perfect matches or analogous principles? Or will SCOTUS pull back and demand closer historical kinship? What about the sensitive places definition? How narrowly or broadly will the Supreme Court define what qualifies as a sensitive place or a site subject to a default carry ban? If they give too much leeway, states could declare many, many public gathering places off limits, and they will. Now, the scope of property owner consent regimes will also be at play. Will the court draw lines around what counts as publicly accessible private property, malls, restaurants, retailers, versus purely private property? Will there be exemptions that come out of this? Will they concur or will they dissent on opinions with separate rationales? Watch for dissents or concurrences here, and sometimes the narrower points there shape future litigation. Which justice authors the majority will be big. The person writing the opinion matters. It may signal the logic that the court favors going forward. Now, typically, they will do those in a revolving fashion. But if, say, Clarence Thomas wants to issue this, well, that will be pretty big. It'll be pretty big. Now, any remand or instructions back to a lower court is another thing we need to watch out for. If the Supreme Court sends the case back, the guidance that they give could reshape how the lower courts apply Bruen and Rahimi in other contexts. But remember, they GVR'd, granted certiorari, vacated, and remanded several cases after Bruen, and the courts haven't changed jack splat. The anti-gun states are still anti-gunning. They're just doing it harder. So we would prefer the Supreme Court to grab them and shake them and do their job. This court takes half of the cases of its predecessor courts. Then maybe they should just get on with it here. My take, I lean towards the Supreme Court rejecting the vampire rule. The Ninth Circuit is an outlier so far, but they may try to finesse some middle ground. A narrow holding rather than a broad ruling is something that I don't want to happen. Now, for folks who carry, if the Supreme Court strikes down or limits the vampire rule, that could free up more places that we can carry, that we can defend ourselves, that we don't have to depend on, cops responding 15 to 20 minutes later when seconds count by default in states where such laws exist, or where they might be enacted next is probably a better scenario. But even in states without a vampire law, this sets a big precedent here going forward. Lower courts across the country will watch this very, very closely, and it will influence future challenges to various restrictions. So what you should do now? Well, always stay informed of what's going on in your state. If a state proposes an opt-in property consent rule, the vampire rule, then that's no bueno. It's no bueno. Now, support good litigation groups and state-level challenges. Your local state-level carry rights matter, and your state organizations are the ones doing the brunt of the work there, so support them. If there's any ambiguity in your jurisdiction on whether a business must grant consent, keep tabs on how the Supreme Court rules here, because that will tip the scales. Now, to wrap up, before I tell you one thing to watch out for that you might not hear in other places, Wolford versus Lopez is shaping up as one of the most important Second Amendment cases, period. Never mind the first one of this term, but period. The decision could clarify or reshape the doctrine of historical analogs, could limit or expand the scope of carry restrictions, and set the tone for future gun rights litigation. If the Supreme Court doesn't destroy this law, then the Second Amendment will be hollowed out and basically useless. They would empower states to make us opt in to the Second Amendment rather than have private property holders opt out. Name one single right other than the Second Amendment where that is allowed. You can't. A Second Amendment that can only be exercised in the middle of a street far away from anything else and not on a sidewalk or a parking lot or in a business or any other place in this country is not a Second Amendment right to keep and bear arms. It is not your right to self-defense. It's simply just worthless and worthy of a reset. Now, one thing I said to watch out for that you might not hear in other places. Could Hawaii do what New York did in the first attempt at challenging New York's carry laws before Bruen, which was just vacate its own law before the Supreme Court case actually is taking place? Yes, they could. That would moot the case, which would mean the Supreme Court wouldn't hear it. But what it could do, if that's the case, it could piss the Supreme Court off to where they take other cases just to drive a point home. Think an AWE case, a magazine case, stuff like that. Because there are a couple solid cases before them right now waiting to see if they are going to issue a writ of certiorari. So they're going to take the case up. So we will see what this ruling, exactly what the Supreme Court justices believe about the Bill of Rights. Do they even matter anymore? Do we need to have a reset? All those things we will learn from this case and how they rule. So if you want to stay updated on the Supreme Court rulings here, or how they affect the carry laws, or get in-depth analysis here, this is exactly the kind of stuff I cover here on Guns and Gadgets. Now check back often. I post generally every day. I did take this weekend off because I was in New York at an event. But if you found this breakdown useful, like the video, hit subscribe, and ring the bell so that you don't miss future updates. Drop your questions or your thoughts in the comments down below, but answer me this. What do you think the Supreme Court will do here? They've already agreed to hear the case. Will they uphold or strike down the vampire rule? Thank you for watching, and until next time, stay safe, stay informed, and stay armed. But most importantly, stay free, America. Take care.